If you want to record, you can record it on your own machine. Good evening, everyone. So we would like to start a new discussion. We'd like to move straight to discuss terms of contracts. When we are done with terms of contract, which is a very broad topic, and we come back to two minor topics, which are very light. That is intention to create legal incapacity. So we would like to begin right away without wasting time. So first and foremost, we would like to understand the need for content or terms of contracts. So students should know the various types and categories of terms of contracts and also how to identify them. And again, it is pertinent for us to know how various terms are going to be considered in Ghanaian cases and statutes as well. So without wasting time, we would like to start. And I would like to remind you that in some textbooks, you would not see terms of contract. You will see what we call the contents of the contract. It's the same thing. Whether we are talking about terms or we are talking about contents of the contract, we are essentially talking about the same thing. And it is useful to remember, as we know that that is an agreement. Yes, that is true. And the terms of a contract express what the parties to the contract have agreed. A contract essential agreement that yes, somebody has made a proposal, another has accepted and all that. But fundamentally, what have they agreed upon? What is it that they have agreed upon? That which they have agreed upon is what would amount to the contents of the contract, the terms of the contract, as it were. Now, where the contract is in writing, a term or what is contained in it is generally referred to as a clause. So maybe you say that the clause 3 of the contract or agreement, or clause 5, that is to say that, yes, we are dealing with the written contract and we are making reference to the things which are contained in it. So that is what we should keep in mind. And another point to also remember is that we are talking about, as we stated earlier on, we are talking about express terms and implied terms. So we like to first and foremost explain what these two means, and then we take them one after the other. So when we talk about express terms, we are referring to those terms which the parties have negotiated and agreed upon. So those are express terms. The parties have consciously considered them and they have accepted that they should form part of the contract, hence express. Implied terms, on the other hand, refers to those terms which have not necessarily been negotiated and agreed upon by the parties. Nevertheless, for some reasons permitted by the law, they are considered as forming part of the contract. They are considered as content of the contract. So they are implied. And as I said, for reasons permitted by law. And in the course of our discussion of this topic, we will come and explore circumstances in which the court or the law would say that certain terms which the parties have not necessarily negotiated should still be regarded as forming part of the terms of the contract. So having known in a nutshell the difference between having known in a nutshell the difference between express and implied term, we will proceed to take them one after. I think I have muted all of you. So if you want to speak, you have to use the chat so that I can release you or something like that. Good. Because some of you were still making noise. Good. Yeah, so now we would like to take express terms. What are express terms? Okay, Samuel, you want permission to record? Okay, Samuel. Yes, you can record. Yeah, I think you can record. Who else? Okay, so what are express terms? By express terms, as we have explained already, we are talking about what the parties said or what the parties wrote, because those are the things they will have negotiated, applied their minds with, and come to some consensus or come to understanding of that. So those are express terms. Now, if we take a contract may be written or it may be oral. It's also possible for it to be partly in writing and partly oral. So let's take oral contracts. Where the contract is oral, in other words, it has not been reduced into writing. How do we determine the terms of the contracts? How do we determine express terms? How do we find out what is it that the parties actually say or what they wrote? What is it that they agreed upon? Here is the case, the contract we're dealing with is not in writing. So how can we be sure of what forms part of a contract and what does not form part of a contract? So those are the matters we want to be exploring. As far as oral contract is concerned, the terms must be found as a fact, exactly what it was that the party said. So we are interested in finding out when they were negotiating or having conversation, leading eventually to the conclusion of the contract. What exactly did the parties say to each other? Now that certainly will be a matter of evidence. A matter of evidence in the sense that you will need to try and get proofs to show that at the time of negotiating the contract, this was said or that was not said. A very useful authority which provides guidance in trying to establish what the parties said to each other at the time of making the contract is a well-known case of Smith and Hughes. Smith and Hughes is a very useful case, a case which was decided a little over 100 years before I was born, very useful case. And you remember, in that case, there was a controversy or dispute regarding the subject matter of the contract. Was the contract about old oats or new oats? So the question was whether the subject matter of the contract for sale was described by the vendor as good oats or as good old oats. That was the crux of the matter. One party was saying that, well, we agree to sell or buy good oats, simpliciter. Another party will say that, no, that was not the agreement. The agreement was about good old oats. So again, in terms of being able to establish, determine what the parties really agreed upon, you need to call evidence. You need to adduce evidence. Quite apart from Smith and Hughes, we see another example of where there was the need for the court to determine what the parties actually said to each other during the contract. And I'm referring to the case of Oscar Shares against Williams. Very interesting case. A car was offered in part exchange. And if you look at the registration documents, it had incorrect dates. And the truth of the matter was that the car was much older than the date stated in the registration document. Now, regarding a statement or representation which had been made as to whether the date of the date stated in the registration document, for example, was a term of contract or not. It was held that that representation could not be treated as forming part of the contract or as being a term, as the car dealer was in a better position to discover the rear age of the vehicle. So the court was saying that, yes, if a car dealer is dealing with a lay person is, for example, selling a car, and we say that the car is, let's say, 10 years old. Let's say when in fact the car is about 13 years old, and the prospective purchaser is a car dealer. The court seemed to be saying that because of that person's expertise and background, he or she is in a better position to be able to discover the real age of the vehicle. So, ultimately, in trying to look at evidence to make a determination as whether something was said, and for that matter, meant to form part of the terms of the contract or not, it is very helpful to make use of the well-known approach in law, which you call the objective test. Objective tests. By objective tests, which we use to determine what was said, we are interested in what the parties manifested and not the actual intentions. In other words, by the objective tests, we are interested in the external manifestations of what the parties said to each other at the time of making the contract, and not necessarily what one person thought he was telling the other or not. So that is one thing that we should keep in mind. So that is about the objective tests. And if you remember from last semester, and from the very introductory chapter to Mrs. Jonah Hammond book, as well as the Shesha and Pfeiffer, we have like a extensive discussion of the objective tests. And essentially, we are told about the objective tests. We are interested in, if you take, let's say, A and B, having a discussion leading up to a contract. And let's say A will say that, no, this was not what I said, or this is what I meant. And B will say that, no, this is what I meant, and so on and so on. Now, how do you resolve a conundrum or a difficulty like that? Now, by the objective tests, we will be interested not in what A meant or what A in his subjective mind intended to have said, and vice versa for B. On the other hand, our main interest will lie in what a disinterested bystander, an officious bystander, a neutral person, let's assume there was a neutral person present at the time A and B were having the discussion. What would have been the understanding of the neutral person as being the agreement reached by A and B? What the neutral person would have understood A and B as having agreed upon is what will be taken as the agreement. So we are talking about the parties manifested and not actual intention, the apparent agreement. The apparent agreement. So what A was actually thinking he had told B is not important as what the disinterested bystander, the official bystander, would have actually understood A to have told B. That is what will matter. So that is how the objective test works. And you notice that a lot of examples are cited, and we can make reference to the case of, let's say, Tamplin and James. If you remember Tamplin and James, for example, Tamplin and James, there was an auction in which a certain house called the Ship Inn was put up for sale. Now there was a prospective purchaser, the defendant herein, who was very conversant with this particular property that was being put up for sale, because he used to move around the very vicinity or neighborhood in which the property was situated. So at some point, when he got to the auction room in which that property had been put up for sale, instead of taking his time, being patient, and reading the brochure, the document which the auctioneer had put forward for purposes of giving description to what was being put up for sale. Now, this person was a bit foolhardy. He just made a bid and right away offered to buy the property, and same was accepted. Now, subsequently, when it was time for him to pay, then he realized to his disappointment that the property that he had purchased, that he had made a bid for, did not actually include a certain adjoining garden, which he thought was part of what was being offered for sale, because the garden was very much by the side of the property. So this person thought that once that property was being offered for sale, then that garden was also up for grab. Unfortunately, it wasn't part. So this purchaser didn't want to complete the transaction, and the auctioneer had to see him for specific performance to get him to complete the transaction. And the purchaser put up the argument that, well, he thought that he was buying the house with the garden, but the court said that what he thought was up for sale is not important as what a reasonable or disinterested bystander or official bystander would have understood the auctioneer as having put up for sale. And for that matter, a reasonable person who have read the brochure will have known that the garden was not part of the house which was being sold. So I cited Tamplin against James, a case that you ought to have read last semester, to just drive home the fact that by the objective test, the courts are interested in what the apparent intentions were, not the real intentions. And that was why, in the case of Take and Morris, very interesting case. Interesting in the sense that a couple who have been having probably, they were probably highly fertile. It's interesting. Some people are struggling to get children, others too. They say, that's for me. As soon as I and my husband, we meet, there's conception. And because of that, some people even go to the extent of depriving themselves of some of their conjugal package, because they don't want to get pregnant, and they also don't want to commit the sin of abortion, which God is not happy with. So then, if that is the case, then they will not have the act at all. But in Take and Morris, this couple went to a private clinic and said that they wanted the doctor to carry out a procedure on them so that pregnancy will not be possible. So that was the deal, that yes, we want a procedure so that when we don't get pregnant. That was the deal. They paid for it and all that. And eventually, after some time, they still got pregnant. So they decided to sue the doctor who provided the procedure. And they were claiming that the doctor had actually breach the contract. Now, in the course of that judgment, Lord Justice Neil, that is the case of Take and Morris, made a very instructive dictum, which I quote, "It is a common experience of mankind that the results of medical treatment are to some extent unpredictable, and that any treatment may be affected by the special characteristics of the particular patient. It has been well said that the dynamics of the human body of each individual are themselves individual," unquote. In other words, the court was trying to make a determination. Now let me continue. Lord Nelson speaking. The reasonable man would have expected the defendant to exercise all the proper skill and care of a surgeon in that specialty. He would not, in my view, have expected the defendant to give a guarantee of 100% success. So stressing that the operation was irreversible did not amount to giving a guarantee that it will work. No binding promise. In other words, the court was saying in Take and Morris that by the contract which the couple made with the doctor for the procedure, was it part of the terms of the contract that the procedure will be irreversible? In other words, once it is done, then you cannot get pregnant again. And that was why the judge was saying that, okay, we need to find out what will be the position of the reasonable man. If you are using the objective test, knowing that human beings, our bodies are different, so that how paracetamol may work on patient A may not the same for patient B. Would a reasonable person understand that by the contract that the private hospital and the couple made, they actually intended to say that the procedure which was being performed on the couple was going to be irreversible and they could not get pregnant? Was it 100% assured? Now, Lord Justice Neil said that any reasonable person conversant with the fact that human beings, and for that matter, our bodily constitution are different, would never have understood the parties to have actually accepted irreversible procedure as part of the contract that they made. So let's keep that in mind. So in a nutshell, when the court is trying to find out the express terms, that is the terms that the parties agreed upon, where the relevant contract is oral contract not reduced into writing, the court to be guided by what we call the objective test, and that is what we've been discussing so far. Now, what about the situation of written contract, where the contract is in writing? How will the court determine the terms? In other words, if you have a written contract, how can we be sure about the exact terms that the parties agreed upon? So that is what we want to explore now. Well, as far as written contracts are concerned, we have certain rules of thumb, and one which is quite handy is a well-known parol evidence rule. Parol evidence rule. And what do you mean by the parol evidence rule? By the parol evidence rule, we are simply saying that where the contract has been reduced into writing, then the written contract will be considered as the entire contract, and everything which forms part of the contract must be located within the four corners of that written contract. And for that matter, no extrinsic evidence will be admissible or will be receivable by the court to vary or contradict that which the written contract or the instrument is saying. So there are plethora of authorities or long line of authorities which supports the parole evidence rule that no extrinsic evidence is permitted to vary, contradict a deed or other written instrument as it were. So we can look at the case of Jacobs against the Batavia and General Plantation Trust, the case of Pond and Anafi. Look at the beautiful words of Bamfo, the case of Gorman and Gorman against Anson, and then the well-known case of Wilson and Broby. Wilson and Broby, very interesting because in an action against the defendant to recover the value of goods credited to the defendant by the plaintiff, the plaintiff tendered in evidence an invoice which had been marked as Exhibit A. And this invoice, that is Exhibit A, had been signed by the defendant. Now, although the defendant was literate, during the trial, he admitted signing the document, but he insisted that when he signed it, he was signing it as a guarantor on behalf of another person, and he was not signing it as an invoice he has committed himself to accept as he like being responsible for whatever the invoice related to. No, he said he was just signing it as a guarantor for another person to whom the goods have been supplied. So he was saying that, well, I'm not the one for the goods, so if you need to sue for the price, don't sue me, sue the other person. And for that matter, when he was sued, he decided to join A as a co-defendant. And during the trial, the magistrate rejected the defendant's contention and found for the plaintiff on the strength of the oral testimony coupled with Exhibit A. Eventually, the decision of the district court was appealed against. And when it came to the court on appeal, the court held that where parties had embodied the terms of their contract in a written document, extrinsic or oral evidence would be inadmissible to add to, vary, subtract from, or contradict the terms of that instrument. In other words, the court was saying that what a person thought when he signed a document and so on and so forth is not important. Let us look at what the document is what it's saying. And for that matter, we're saying that where you're dealing with a written contract, then the terms are what can be found on the face of the contract. And no information, be it another written document or parole or word of mouth, outside this document you're dealing with, will be entertained to vary or contradict what it is saying. And this is what we call the parole evidence rule. So this parole evidence rule, if you look at our Evidence Act, the legislation on evidence, you'll notice that it has been given a statutory footing. So if I would like you have the interest to know more about it, you can look at the section 177 of the Evidence Act 1975, NRC Decree 3. Now, what we said, the parole evidence rule, that is the general principle. Is there exception or are there any exception to the parole evidence rule? In other words, is it ever possible where you have a written contract for external extrinsic evidence to be admitted to contradict what the written contract is saying? So we will look at the well-known exceptions. So first of all, there may be an exception in the parol evidence rule where the contract you are dealing with is partly written and partly oral. In other words, it's not the entire contract which is in writing. You have aspects of it in writing, and then you have the other aspect not in writing. Now, what that means is that if we take the writing, the written part or the partly written will not be a full picture or representation of the contract, because part is in writing, part is by word of mouth. So therefore, the parol evidence rule cannot apply strictly. An exception is permissible. And it is very insightful to look at the case of Walker Property Investment against Walker. Now, in Walker Property Investment against Walker, the defendant negotiated to take the lease of a flat from the plaintiffs. And the defendant, by word of mouth, stipulated that if he took the flat, he will be able to use the basement for storage and use the garden. The plaintiffs agreed, but the subsequent formal lease omitted this undertaking. In other words, what had been agreed at the oral level did not find its way completely into the written version of the transaction. And for that matter, the Court of Appeal, the English Court of Appeal, held that the oral agreement should be read with the written instrument so as to form one comprehensive contract. Because as we indicated, the fact that the contract you are dealing with, part of it is in writing and part of it is by word of mouth. Then where there is, for example, stated in the written part and is not clear and so on and so on, it will be proper for you to admit external evidence or stringent evidence in order to illuminate or shed light on the situation. So quite apart from Walker Property Investment against Walker, it is also useful in the case of Coachman against Hale. Coachman against Hale. Another way by which we have an exception to the parol evidence rule is when you are dealing with the collateral contract. I would like you to just pause for 1 minute for me. I'll just join you in 1 minute. Okay, so I was talking about the fact that we can have another way in which the parole evidence rule will not apply, and for that matter, extrinsic evidence may be admissible. And that is where you are dealing with collateral contract. So when we say collateral contract, we are referring to the idea or situation where you have like a main contract and then you have a subsidiary contract. So the subsidiary contract, as it were, is the collateral contract. Maybe let us look the case of City of Westminster Properties against MAD as an illustration of what we mean by collateral contract. Now, in City of Westminster Properties, the defendant had been a tenant of the premises in question for 6 years. And he resided at the shop within these premises. In the course of time, the lease expired and there was a need for renewal. When the lease was renewed, the property owner, that is a plaintiff, inserted a clause for use of the premises to be for business purpose only. In other words, if you remember our discussion of a contract in restraint of, when we were discussing privity of contract, we came across restrictive covenant. So City of Westminster against MAD, there was a restrictive covenant that the lease, that is the property which was being leased, should be used for business purpose only and not any other. This is what was contained in the written lease which was being renewed. Now, the defendant asked a question. If he could sleep there, and the property owner, plaintiff, told him that he could sleep there. So this lessee or tenant or the defendant, relying upon the assurance of the property owner that he could also sleep there, he went ahead to sign the new lease. Now, if you look at it closely, the assurance which the property owner, that is a plaintiff, had given the defendant clearly contradicted the lease or was not in tandem, was not in agreement with what the lease was saying. Because the lease had a restrictive covenant that, yes, this property is for only business use, no other. So this is what is contained in the lease. And here is also the case that the property owner, by word of mouth, has assured the defendant, who for a long time had also been residing in the shop before the lease expired. He told the defendant that, yes, you can sleep there. Now, later on, when there was a dispute and the matter came to court, the court was prepared to admit evidence, extrinsic evidence, in order to prove that apart from the main contract, so the main contract being the lease, there was a supporting or a subsidiary contract, a related contract, which we call that is the assurance that he could sleep there. So that was the collateral contract. So the court was prepared to go beyond the lease document and take extrinsic evidence in order to help the court to establish whether, as a matter of fact, there was another subsidiary contract apart from the main or substantive contract. It is also pertinent to note that extrinsic evidence or evidence of prior agreement might be admitted to construe a document where there were conflicting or contradictory terms, or where such evidence will elucidate intention of the parties. In other words, even as was seen in the case of Gorman and Gorman against Anson, should you have a written contract, should you have a documented contract which contains contradictory terms? In other words, maybe clause A is saying something which is contradicted by clause 8, and so on and so forth, the same contract. So what do? Where that is the case, it is permissible for extrinsic evidence to be admitted in order to correct the contradiction, in order to resolve the conflicting or contradictory terms. Now, so having known what express terms are, how to determine or how to find out express terms if you are dealing with a written contract, and how to find express terms when we are dealing with oral contracts, we would like to move our discussion forward. But before doing that, I'll pause a second if anybody has got a question or any further contribution to make. You can just raise up your hand, or no, put it in the chat. I'll look at your question and answer. Okay, that is good. And let us move on. So we will now do a very important aspect of our discussion, and that has to do with attempting to draw a distinction between terms of contract and representation. In other words, how do we classify pre-contractual statements? When I say pre-contractual statements, as the word indicates, pre-contractual, pre means before. So before contracts, various statements are made by the parties to each other. So the question is, how do we determine which of those statements are meant to form parts of the terms of the contract, and which of them are not meant to form part of the contract? So we are moving to a distinction between terms and representation. And this distinction is important. Why is it so? Because where you classify a statement made at the pre-contractual stage as a term, you are saying that it forms part of the contract. And that is also important because it has got its own implications or consequences. And we will be exploring that in a minute. Now, if you have classified a pre-contractual statement as a term, what that means is that it is binding. Binding in the sense that the parties must do what the term says. And if that is not done, it will produce certain legal effects, certain consequences. A term is binding, so if you don't do what it says, then we say that you are in breach of contract. You are in a breach of contract. Because the contract term says you should do certain things which you haven't done. So if you don't do it, you're in a breach of a contract. Now, on the other hand, if a pre-contractual statement is classified as a representation, it does not form part of the contract. And for that matter, the parties do not have to do what it says. There's no obligation on the parties to do what it says, because a representation does not form part of the terms of the contract. What then is representation? A representation is a statement made to try to get someone to enter into a contract. So the maker of the representation, if you like, we can call the person representor. And then the other party to whom the statement is made, we can call that person the representee. So what has happened is that the representor would like the representee to make up his or her mind to enter into a contract. For that matter, the representor will make the representation, will make the statement of fact with the sole aim of inducing, that is, exciting or persuading the other party, the representee, to want to actually go ahead and enter into a contract. So let us keep that in mind. Now, another point worth noting is that the overriding importance of drawing a distinction between a term of contract on one hand and a representation on the other, or the necessity of classifying pre-contractual statement made at the negotiation stage as either a term or as a representation lies ultimately in the remedies that are available. So therefore, if a term of contract is broken, as we have said not long ago, this may give rise to an action for breach of contract. If a representation proves false, this may give rise to an action for misrepresentation. And later on, we'll discuss misrepresentation as part of vitiating factors. And then that is the last but one major topic which we'll discuss in the semester. So now, having known the importance of making a determination as whether a pre-contractual statement is a term or representation, we need to find out, how do we go about trying to say that this statement, which was made at the negotiation stage of the contract, is not a term, or it is a term, or it is a representation and not a term? How do you do that? Well, in the literature, there are four main ways of trying to make a determination as whether a statement made at the negotiation stage is to be treated as a term or as a representation. What are these four ways? What do we call like the tests? So first of all, not in any particular order, the importance of the statement. How important was the statement? 2, the time between making the statement and making the contract. The time interval. The particular statement you want to classify, was it made long before the contract was made, or it was made just closer to the contract or just at the time the contract was being made? So the timing of the statement will also help us in determining whether it is a term or representation. The third way, or the third test, is that whether before a written contract, an oral statement had been made. If the statement you are trying to classify was made viva voce, that is oral, by word of mouth, and subsequently there was a written contract, and that statement did not find its way into it. And that is significant because it will help us to also determine whether it is a term or a representation. And finally, the relative expertise of the maker of the statement and the person to whom the statement was made is also pertinent indicator in trying to make a determination as whether the statement is a term or representation. So let's take them one at a time. Importance of the statement. Now, if the statement is so important that someone will not have entered into the contract without it, then it is a term of the contract and not a representation. So put simply, the greater the importance of the statement, the more likely that it was intended to be a term. It was intended to form part of the terms of the contract, and not just a statement which was made to persuade the other party to want to enter into the contract. So I'll give you a very simple example. Angela is a vegetarian. She does not eat any meat, of course. So she orders a pizza. And when she orders the pizza, let's say Abude, I'm sure that is, or KFC. I don't know KFC if they have a good pizza. We have some pizza eaters here. Pizza eaters, can you confirm whether KFC have pizza at all? Well, I don't do pizza often. Okay. So this vegetarian, Angela, orders a pizza. And when she orders the pizza, she asks the restaurant if it contains any meat. If the pizza contains any meat, they say no. So look at it. Somebody is entering into contract to buy pizza and find out, please, does your pizza contain meat? The seller says no, it does not contain meat. Now, going by the principle that we are discussing, that the greater the importance of the statement, the more likely that it is a term. So the reply by the restaurant that the pizza did not contain meat will be considered as a term of contract, because Angela, as a vegetarian, will certainly not buy pizza which contains meat. So that is one thing we should keep in mind. Let me look at the time, because I'm still in my office and I need to go home. Yeah. I think I've done 1 hour plus. Okay. Any questions so far? Any questions so far? Okay. So a lot of material has been crammed in a little time. So we'll end the class here and we will, subsequently. So just watch the platform for information. Yes, if you have a question, just ask a question. Yes, put it or read it. Samuel, let me stop the recording now.